Qualified immunity is a legal doctrine designed to give public servants, like town officials and police officers, protection from personal liability for violating someone else's civil rights while performing official duties unless the official violated a clearly established constitutional right. On the one hand, defenders of the doctrine say it's necessary to protect government officials and police officers who could face severe financial hardship for decisions that have to be made quickly under stressful conditions. According to the National Council of State Legislatures, the Supreme Court has offered multiple justifications for qualified immunity, including that it encourages government officials to, quote, unflinchingly discharge their duties, unquote, without worrying about being sued for actions a court has not yet held to violate the Constitution. On the other hand, opponents argue it's a way to avoid accountability for wrongful actions and makes bringing lawsuits in response to those wrongful actions more difficult than they should be. The Vermont Legislature is considering a bill which would eliminate qualified immunity as far as it applies to police forces. State Senator Dick Sears, who chairs the State Senate Judiciary Committee, is backing the bill with three co-sponsors, Senators Becca Balint, Philip Baruth, and Keisha Hinsdale. James Baker, who until recently was serving as the commissioner of the state's Department of Corrections, capping off a long and distinguished career in law enforcement which saw him serve as the commander of the Vermont State Police, as well as tours as the chief of police both in Rutland and Manchester, has concerns about eliminating the protection, and certainly as it applies to police officers and those in law enforcement. We had a chance to talk with both of them recently to hear their views.
Unlike other laws, this has been not passed by any legislature. This was a thing that the Supreme Court did back in the 60s. And in the 80s, it started to take a turn where the Supreme Court, United States Supreme Court, and the Vermont Supreme Court has done the same, where the facts had to be basically the same. There had to be a previous case with virtual identical facts. And on that basis alone, somebody could be denied their constitutional rights, denied that their rights were violated, and their suit is dismissed. So some of the more egregious ones obviously happened in other states. There's no question about that. In Vermont, there's been several cases. The one I will talk about is Keene versus Snyder. And the troopers were permitted to enter Mr. Keene's home. They questioned him in his living room about a possible DUI. The troopers decided to arrest him on suspicion of DUI, which was later dismissed by the state's attorney, by the way. And he refused to go with them. The troopers pepper sprayed him, took him to the floor, repeatedly punched, elbowed, and kneed him in front of his crying 14-year-old daughter. The district court in Vermont denied qualified immunity for the trooper, but it went to the Second Circuit of the United States courts, and they reversed the ruling, granting qualified immunity because the trooper's action did not violate clearly established law without deciding whether the force was excessive. There's been other cases in Vermont of a similar nature. And so there has been a nationwide effort to change qualified immunity, either through legislation. And the bill that I introduced along with Senators Baruth, Hinsdale, and Balint is modeled on the Colorado law. Now, there have been over 35 states introduced bills on qualified immunity, and only 2 states have actually passed them due to heavy lobbying efforts and by law enforcement particularly, but other groups like the Vermont League of Cities and Towns, which have fought this and are fighting it here in Vermont. So when we introduced the bill based on Colorado, it had several provisions. I'm not suggesting that we have any disrespect for troopers or police, local police. I have the greatest respect for them, the tough job that they do. But this just seems something that the legislature should at least openly discuss. And that's what we're doing. And I said right from the beginning that if there are other alternatives, if there are ways to make this law that's been developed through case law and not legislation improve, so that when there are egregious cases like the two that I described, people can have their day in court and not have their civil rights or constitutional rights violated. And we've had 2 hearings on it in Senate Judiciary, and we're going to continue to listen to both sides. And in this case, there's probably 4 or 5 sides to it. One of the concerns is, and I understand that, is like everything else these days, is recruitment is very difficult. Whether it be troopers or grocery store clerks or nurses, or you name the profession, we're having a hard time filling those positions. So I understand that, and if we need to, we are trying to address that in the Senate Appropriations Committee, by the way. But we're going to continue to hold hearings. We're going to continue to look at the issue. I don't know where the bill will go. I really don't. This is not one of those where I feel like, wow, we're going to make it, and we're going to do this. So, that's pretty much what it is and where we're at right now.
We then paid a virtual visit with Colonel James Baker to hear his take on the issue.
Qualified immunity is a legal defense. It doesn't prevent anyone from filing a lawsuit if they have been grieved by the government. Now, what the bill proposes is taking qualified immunity out of everyone who has the right to the defense of qualified immunity, which I'll tell you what the clearly established law means in a minute. Out of everyone that's entitled to qualified immunity, from select board members to highway department drivers to state health department officials to town managers, town administrators, out of everyone who's covered by qualified immunity, the people they want to remove that legal defense from are police officers who probably face some of the most challenging situations that are fraught with opportunities to have bad outcomes. And so what the concept of qualified immunity is, it's a legal defense that is set by not only the U.S. Supreme Court, but the Vermont Supreme Court has ruled on it as well. And in the current tests for clearly established law, the facts of the case alleged by the plaintiff who's suing shows that the government official's conduct violated a constitutional right. That's part of the standard. The second part of that, which is the important part, that at the time of the allegation of the violation, that the violation violated a clearly established law or decision at the time, a court standard at the time of the alleged conduct. What the legislation would do now is remove the clearly established standard. So think about that for a minute. You would, as a police officer, you would be making decisions wondering what the court may rule on in the future to establish a standard. It puts police officers in an almost impossible position. And it doesn't, as some people would say, even the senator's letter to the paper, would leave people with the impression that it shuts you out of the ability to file a lawsuit. That's just not factually true. Unfortunately, in my career, I've been involved in lawsuits where I've been named in lawsuits where unjustifiably I've been named in lawsuits. And I think people may not understand this because they think qualified immunity prevents people from having access to filing a lawsuit. It's just not factually true. And all you have to do is look at the latest lawsuit that's been filed in Bennington County against the state police for $25 million. That lawsuit has been filed. The judge will decide if qualified immunity, a motion will be made by the attorneys representing the state to invoke qualified immunity to remove the officers personally from the lawsuit. That's what qualified immunity does.
So if someone feels they've been unnecessarily physically roughed up by a police officer in an encounter, what's their recourse then? I mean, do they have some way of saying, "Hey, I really felt like the police officer was over the top in this situation"? They do have a way to get some recompense for that.
What is the recourse? There's a recourse through the agencies. There's a recourse through the Criminal Justice Council certification and decertification, and you can still file a lawsuit if you believe that you were grieved.
Mm-hmm.
Qualified immunity is only part of the process to provide a defense for police officers being personally held responsible for the action. And again, I think everyone would agree, you shouldn't be trying to hold someone accountable for their actions on a standard that isn't set yet. That's why law enforcement is so opposed to the conversation about changing qualified immunity. What the law would do now is a judge would rule later a new standard and hold the officer to that new standard post the bad act. And I think, again, that's why I think law enforcement and why I think going down that route feels really punitive towards law enforcement officers personally.
According to a recent news report in VT Digger, recent polling shows nearly 3 in 4 Vermonters support eliminating qualified immunity in the state, and that support extends across the political and geographical spectrum. Currently, the bill, known as S-254, is under consideration in the Senate Judiciary Committee. For the GNAT-TV News Project, I'm Andrew McKeever.